Hello, good afternoon. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. And I have a very good topic for you today, and it is getting your green card through a step parent or a citizen stepchild. That is possible, and I'm going to tell you how you can do that. Now, you can do that even if, for example, you have now lost or you no longer have a relationship with your step parent or your stepchild and you're no longer living with them because maybe they may have mistreated you. In that case, you could also apply for VAWA, and VAWA allows you to get the green card on your own, and this will not be a situation where you will be the step parent or the stepchild will be notified. So in two situations, you would be able to get your green card through a step parent or a stepchild. Through if the step parent or the citizen stepchild wants to sponsor you, they can do that if you meet certain criteria, and I'm going to tell you what that is. Also, your citizen stepchild can sponsor you. So if you married the citizen's parent, then you could also, the stepchild could apply for you under certain circumstances if they're 21 and up. No, and there are conditions that you need to meet. I'm going to jump into those in a minute. Now, if that step parent or that stepchild mistreated you, you had to leave the situation, you're no longer living with them because they mistreated you, or it created a rift in your own relationship, and so you are now even divorced. Guess what? That option is still there to be able to apply for your own green card based through VAWA based on the mistreatment. But even if you are divorced from, say, the parent and you have a stepchild, you could possibly sponsor your stepchild if you continue, if you have a relationship with them, you continue to have a relationship with them, you could still petition for them even though there's a divorce. And the same occurs in VAWA. Of course, you do have 2 years after the divorce to be able to file for this. So it is a valuable, this is valuable knowledge that a lot of people don't know. If you have a US citizen or a legal permanent resident parent, or you have a citizen son or daughter, stepson or daughter who's 21 and up, then in the situation where they mistreated you or they would like to apply for you to get the green card, there is the possibility to do that, but you should go ahead and make sure that you schedule the consultation with me to confirm you qualify, and then we get started very quickly to get it done, whether it's a situation where you are mistreated by that stepchild or that step parent, or the both of you, your stepchild or your step parent wants to sponsor you. Now, that is an important piece of knowledge. Now, let's get into the criteria. There is very specific criteria under immigration law. Now, in our everyday lives, you have, once your parent marries someone, that person becomes the step parent, and you become the stepchild, and vice versa, right? Now, if you, under immigration law, the only way to qualify as a qualifying step parent or stepchild to be able to get the immigration benefits is if so for example, if you're the immigrant and your parent married a citizen or resident person, that person would then become your step parent under immigration law as long as they got married before you turned 18. So your age as the immigrant child is going to be very important. The child's age is going to be very important. Your parents have to be married before you turn 18 to get that step parent, stepchild qualifying relationship. So that's where you have to be very careful. But once you do have that relationship, then, for example, if you're the stepchild and your step parent wants to sponsor you, They have up until you're 21 for you to go through the faster process. Once you turn 21, it turns into a 5 to 7 year process. So if you're under 21, you have a US citizen parent, get on it right away. Schedule that consultation. Let's understand whether you qualify and get started. So I'm going to reiterate. If you're under 21, you have a resident or citizen parent, a step parent, and that step parent married your parent before you turned 18, then you may be able to go through a faster process and you may be able to go through adjustment of status. Now, even if there's divorce, up until 2 years after the divorce, you may still be able to apply for this. And in the case where the step parent wants to sponsor you, it's not VAWA, they just want to sponsor you, there's no 2-year limit. However, if you're applying based on mistreatment, you have those 2 years to make sure that you apply within those 2 years. And that also applies with VAWA if the step parent passes away or if they're removed or they lose their status. So now that I have said this part, and now you know that there may be a potential option for you, I'm going to leave it up to you to give me a call and schedule that consultation. This is what I help my clients to achieve. Go to the link in the profile and you will see everything you need there to schedule your own appointment. Thanks for the love. I'm going to go ahead and answer your questions now. Let's go. I see a ton of questions coming in, and let me remind you, I'm here to answer those questions on YouTube as well. Okay. Thanks for the follow. Will I be able to travel if I'm married to a green card holder if I overstay? We just had a kid. So definitely get legal advice. It's on when you overstay, you're in the United States, you have a problem. You would not be able to travel unless you apply for a travel document through the adjustment of status process. And usually you can't, with a green card holder spouse, if you've already waited until you're out of status, you will not be able to apply for adjustment of status. This is a good time for me to remind you all, if you are married to a permanent resident right now, if you're here with legal status, don't wait until you overstay, because guess what? Right now, if you have legal status and you're married to a permanent resident, you can adjust status right now. Because it is current. That is going to change eventually. So don't make that mistake of overstaying and then try to find out your options later. If you are still within the time permitted on your B1, B2, it could be you're maybe on a student visa, you're on another type of visa. It is current, you haven't overstayed, you can submit an adjustment of status application generally. Now, whether that's advisable for you in particular is going to depend on your circumstances. I'd have to evaluate. But I want you to know this so that you can, on an urgent basis, go and get legal advice and get help to file the adjustment of status, because you can do that right now. And I'm seeing a lot of people, they end up overstaying. They're overstaying and then they have a problem. So don't do that. Make sure that you go ahead and find out if you qualify to apply right now while you're in status to change status. So if you have not overstayed, get in touch with me. Let's schedule that consultation and talk about your process. You can call right now. Scheduling coordinators are available. And if you go to the link in the profile, you will see the link to go ahead and schedule your own appointment. Highly, highly recommend you go ahead and do that. All right. Thanks so much, Pure Pressure. Hi there. It's nice to see you in Guyana. After a DWI, how long to wait before applying for citizenship? So you may not have to wait. Having a DWI doesn't necessarily mean that they're going to find that you lack good moral character. However, how many DWIs did you have? What were the facts involved in your case? Those are going to be the questions. And what do you have in the first place? So, I mean, you're a permanent resident. But, how long was the DWI? Did it just happen? Have you finished? Have you been convicted, or have you gone through your probation or whatever sentence that you have, or conditions that you have? This is where it's very, very important to schedule that consultation, because it's important for me to get the facts to properly advise. Can children, and as we're talking about citizenship, I'm also celebrating a new victory this week. We got 3 approved citizenships, and 2 of those were scheduled for the swearing in ceremony. One just happened yesterday and they're being sworn in on Saturday. The other happened in the last week of July and they're being sworn in on Friday, tomorrow. So they are really handing out those citizenships to those who qualify, and I'm so happy to be a part of that. Now let's move on to questions. I'm still taking questions, so put those questions in the comments. I'm a US citizen. My daughter's out of status over 21 years, but her visa was A3 dependent when she came to the USA. Can I, any chance to help, please? So, unfortunately, that's one of the problematic areas of immigration law right now, is that when a derivative comes to the United States, that's the dependent, they come and they age out. If they don't independently qualify for an immigration benefit or relief, they find themselves out of status, which is disturbing. Now, whether your daughter has options is going to come down to what happened in your case, what's happening. If you're a US citizen, your daughter is over 21 and out of status, it's going to be about a 5 to 7 year process to sponsor her, and she wouldn't be able to stay here to apply unless there's a VAWA situation where a parent, I know you're the parent, but if the other parent mistreated your daughter, maybe that could be VAWA. Otherwise, it's hard to tell you what the options would be unless I understand more facts about the situation. All right. So can children travel in and out of the US? It's going to depend. If they are out of status, they're not supposed to travel out of the US. The children have to have their immigration, papers like everybody else. They have to have the visa, they have to have the passport, so they're not exempted. But whether or not that child can travel in and out of the US is going to come down to a lot of facts. That is definitely a question that cannot be answered just, without getting more follow-up. Can the U.S. Embassy send message to H-2B agency that they cannot send any denied persons to the embassy? Well, I wouldn't. It's yes, theoretically they could communicate with the H-2B agency, but it really depends on what the situation is. Can children travel in and out of the U.S. whilst green card petition is processing for them? So, Mamsie, they will need to have a travel document to be able to leave during adjustment of status. Why is it the work permit delays over a year? So, because it's backlogged. Thanks for sharing the live. Go ahead, put your question in. Okay, I don't have my father's name, so how can he sponsor me? That happens every day. So there are ways to prove paternity. If your father is not on your birth certificate, you don't have your father's last name, then there are other ways. So there's the DNA test that they do request, and there are also secondary evidence to show the relationship. Is there child support? Is there a financial relationship? Is there evidence of emotional support as a parent? How long does the appeal take in Vermont in this time? So it varies, but you could be looking at anywhere from 6 months to a year to get for that to be processed. How long does and I answered that. I-130 approved while in removal. What's your advice? Continue in court or out of court? That is definitely something you have to consult with me. That's a complex question, and it's going to be dependent on a number of factors. Having an approved I-130 alone may not mean that your case is going to be closed. So get legal advice. That is very complex. Can an aunt file for a niece? No. How does the Haitian Reunification Act work? So it is meant to allow the relatives of Haitians to join their relatives here in the United States. How long does it take to get interview for spouse? I submitted all my documents for, so it's taking over a year, but it depends on the embassy. I don't know what embassy you're at, but it's taking anywhere from 3 months to even over a year to get those interviews right now. Can undocumented immigrants travel by flying to a different state? Yes, that is possible. It's definitely possible. And the risk is low. It's not zero, but it is low that anything could happen. How long does it take the appeal? So I answered that. Did you get my question? Go ahead and retype, Island Boy. As a J1 with 2-year home stay visa, would you be able to, would you apply for the no objection waiver? So yes, if you are subjected to the 2-year foreign residency requirement, you'll need that waiver. I have a green card. I have already filed I-130 for my wife. Now she's applying for F1 visa. So there is a conflict there in that there's immigrant intent, and so they may tell you that you have to wait until your spouse gets permanent residence before she can get the F1 visa. However, I'm not your attorney and I don't know your case, and so that's where it's important to get legal advice. I would prefer that you do that before you do anything. Can a sister file for a brother that is over 21 and married? Yes, if that sister is a U.S. citizen and 21 and up. How long does it take permanent resident husband to petition I-130 for spouse? So if the spouse is in the United States, anywhere from 6 months to a year. If they're outside of the United States, about 18 months to 24 months. I have 18 months waiting for an appeal. So if you're waiting for a long time, you need to check on that. There's nothing I would be able to advise you right now because I'm not your attorney. What if an immigrant have a baby in the US? Can the parent come back in the US with that child? It's possible. Whether it's advisable for you, I would have to understand your facts. However, and that does happen, immigrants come in with the children that they have. However, does having the baby give them any special benefits to come back into the United States? No. I spoke to someone who had a baby, and what happened, she came in pregnant and the officers saw that she was pregnant and they confronted her. They told her, okay, she is going to, they're going to give her 1 week to go back to her country, because I suspect that they knew she was going to have that baby here in the US. That's something they look out for. Well, she ended up having the baby and ended up overstaying. She had a US citizen baby. Unfortunately, she overstayed because she stayed to get the passport and get all of that. So a 1 week permitted stay turned into 2 months, and immediately they canceled her visa. As soon as she overstayed, they canceled her visa. But she didn't know that. So she ended up booking a flight back because she needed to get the baby's vaccines and, do follow up for her baby in the United States, because, she felt like her baby, her baby's a US citizen, and of course they're entitled to getting the quality medical care here in the US. However, when she tried to board the plane, they pulled her out. She was about to board the plane. They pulled her off out of the line. and told her that she does not have a visa. They have revoked her visa because of the past overstay. So the moral of the story here is that having a child is not going to excuse any past violations of the visa. If they say that you're supposed to stay a week, you have to stay a week. If you end up overstaying that week, you should really, it's more likely than not that visa is now automatically revoked. So children it doesn't entitle you to any ability to travel to the US whenever you want or to get status here. Can person with visiting visa get a work permit? So no. If you have a visitor's visa, you cannot just get a work permit. Actually, by coming into the United States with a B1, B2, you're actually agreeing to not work. You're saying that you understand you're not supposed to work. So you can't get a work permit. However, going from B1, B2 to another status, maybe even a green card, is possible if you qualify through an employer, through humanitarian means, through a family member, but you can't just jump from a B1, B2 to a visitor's visa to a work permit. How can you check your case at the NVC and reviewing? So there is a portal where you can log in, you can message them in order to check the status. Can a sister file for a brother that's over 21 and married? Yes, the sister has to be a citizen and 21 and over. If you overstay, will that affect adjustment of status? It's going to depend. The rule is generally you must maintain your legal status to be able to file the adjustment of status application. But there are exceptions, and that's if you're the immediate relative of a U.S. citizen. Also, if you're applying for VAWA, if you have a history of overstaying with a T or a U visa, you could still adjust status even with a history of the overstay. Now, immediate relatives of U.S. citizens are the spouse of a U.S. citizen, the parent of a U.S. citizen who's 21 and up, and also the son or daughter of a U.S. citizen who's unmarried and under 21. And unmarried also includes those who are divorced. So if you're under 21 and you're divorced, you could still qualify for this. Great questions. Keep these questions coming. I'm loving the questions. Is it normal if I have 18 months for answered I did one appeal? So it is possible, yes. So that could be on the long end of it, but it is definitely possible. I know it's frustrating. If USCIS come to the house to check for marriage, what should I do? So it's gonna depend on the situation. If they come and of course they don't have the right to just come into your house. And whether it's advisable for them to come into your house, it's gonna depend on your particular circumstances. When they do come to your house and they come to the conclusion that your spouse isn't living there or what you said in the interview is not correct, at that point, it can turn into a more complex situation and even accusations of fraud. So if you are noticing that they did something like that, you need to make sure that you get in touch with an attorney, because the approach here is going to really come down to what's going on in your situation. So for example, that happened with an individual. Of course, I was not their attorney, but they told me after the fact that they were outside of the country and they came to the house. They did not see, they didn't even want to enter the house. They just wanted to see the two spouses together. And because of, they didn't see them, and because of that, they accused them of fraud. So it could turn serious. And this is why it's very important to start out with an attorney, because an attorney can guide you along the way as things develop. And the attorney can address these doubts of the USCIS before it even gets to the point where they're visiting your house. So just make sure you get legal advice before it starts to get out of control like that. It does happen, but keep in mind it's not the typical thing. every marriage-based case is not going to, the immigration service isn't going to show up at your house. So they must have some good reason that they want to do that. And so you want to avoid that situation by getting the help and representation from the start. So for example, with my cases, I provide sufficient evidence. I make sure by the time where my clients are filing, they have a strong case. And I advise about issues like this and coach them through these processes. I give my green card to renew what they are asking for proof of marriage. Why did that happen? So now Nepal, I don't know if it's to the removal of conditions on your card, or is it to renew your tenure? But you need legal advice, because if you're trying to renew your tenure and they're now delving into, giving proof of your marriage, then you might have a problem on your hands where they're going backwards, maybe looking at inconsistencies in your application. So you need to be wary and understand the issues here. Got the work permit in April, but haven't heard anything else. How do I reach out? You can call them. Go to the uscis.gov's website. In the notice, so the receipt notice, they also give you the information to contact them. Usually with my clients, I do it on their behalf, but in your case, if you don't have an attorney, you need to make sure you contact them directly. And if you really have some doubts or issues that you want to sort through before you even contact them, schedule that consultation. How long does it take for the fiance visa when you apply? So you could be looking at maybe a year to about 18 months. Is it better to apply for naturalization online or through paper? So I always apply for my clients online. And so far, the average processing time for me is 6 months. So I live by submitting my clients' cases online. I apply in April, so when you think they will approve it, I have no idea. I'm not the attorney. I don't even know your case. I wouldn't be able to tell you that. So how can the visa be reinstated after it was revoked? It's going to be very hard, because if it was revoked because of a previous immigration violation, they're very unforgiving when it comes to giving you that visa again. Remember, the visa is not an entitlement, it's a privilege. And so once they take away that visa because someone violated the terms that they laid out for them, they're not gonna just give it back easily. It maybe has to be a big misunderstanding. It has to be, there has to be something that convinces them that maybe you didn't commit the violation as they thought, or that no, you weren't getting it back. How much you charge for assistance to provide more information? So my consultations they're $150 for up to an hour. They're very detailed, and that's where I advise specifically. You can go to the link in the profile and go ahead and schedule. What can you do if you don't want to renew your visa if you have been in the country for 50 years? So I'm not sure if you're in the US or you're outside of the US. 50 years seems like a long time, and it sounds like you've been in, I don't know if this is the US, but if you don't want to renew it, that's your choice. But I don't know. You'd have to give me more specifics about your situation. If I'm married on J1 visa, subject to 2 years, when do I apply for no objection letter? Is it recommended? Well, if you want to change status, that no objection waiver, or whatever waiver that's going to apply, is going to be required, because you cannot stay or change status to another one without getting that waiver, or you have to leave and then come back after the 2 years. How long does the process I-130 take? So around 12 months. And then remember, after the I-130 is approved, there's more. If you're doing adjustment of status, they work together. So my cases are anywhere from 5 months to 8 months for adjustment of status involving an I-130. However, if it's outside of the country, it's more like over a year to 24 months at the longest, 18 months on average. Has USCIS stopped issuing visas in Jamaica? It's the embassy that issues the visas, and it may feel that way. They have not, but it is extremely backlogged. So it's taking over years to just get the visa interview. Thanks so much for the compliment on the lipstick. It's Sephora. If your 2 years conditional is expiring by January, when is the best to file for the 10 years? You need to apply for that within 90 days before it expires. Now, there are ways to apply on your own if you're without the spouse, but get legal advice and help through your process. Do you do residential process also, and how much? Absolutely. No, there are over 20 ways to get the green card. The cost is going to depend on which one of those ways you qualify for. That's what the consultation is reserved for, to figure out what you qualify for and then get started. You get the quote there at the consultation. You're welcome. Now I'm heading on over to Instagram. Thanks so much for your questions. Now, when I head over to Instagram, you can join me there and continue to ask your questions. It's the Immigration Attorney. So the Immigration Attorney, join me there on Instagram, and then we can continue to have this conversation. Thanks so much for all your time and all your awesome questions. Thanks for the follows. Whenever you see me on, share the live so that I can share my knowledge, my experience, and people can understand how they may qualify for the process or ask questions about their process. Now, keep in mind, I am a U.S. immigration attorney and I represent clients in all 50 states and the globe. So I don't just represent clients in the state that I'm located in, which is Florida, but I am all over the country and the globe representing clients. So if you have a U.S. immigration issue, I can help you. We do video and phone consultations. Go to the link in the profile and schedule it on your own, or give us a call. Scheduling coordinators are available up until 6:30 p.m. and then tomorrow 9:30 to 6:30 you can call and get started on scheduling with me. Do that before time fills up. Have a great one. I'll see you tomorrow. Bye-bye.